really in large part to support efforts that you have going on around the protocols and to answer any questions you have about the certifications. We want to make this useful for you in your work. We have some stuff we're going to present, but really interrupt us anytime. We'd love to address the things that you care about in this area. And to the extent we don't have an answer to your question, we can connect with the Office on Violence Against Women and get the official answer for you. So I'm going to go ahead and pass it over to Natalie, and then we're going to have Mary Siefman from Also STAR say a few words, and we'll dive right into it.
Okay, thank you, Darren. If you haven't noticed, Tanya put something in the chat to let everybody know, in accordance with Pennsylvania wiretap law, that we are going to be recording the webinar. So if you object to that, just sign off. We, really thought that it was timely that we did one of our presentations during our video check-ins, just to kind of go over some very basic but critical stuff. So when we're talking about the VAWA certifications, they've been there since the beginning when the Violence Against Women Act was, started. Over time, they've added to them or clarified them, but they're very important because if you notice when you apply for your STOP grant, there's a section called the VAWA certifications, and you have to check off the box that you agreed to uphold those. And then when Pennsylvania applies the OVW for its STOP money from the Department of Justice, we in turn have to do something similar and say, we'll work with all of our subgrantees to make sure they're abiding by these certifications. So I think over the years, and I'm guilty of this too, that they've been there forever and ever, and you kind of just check the box and say, yep, we'll do that. But we thought it would be good with the reauthorization of VAWA to just do kind of a refresh and a reset, particularly since there's a new certification around evidence-based prosecution. The other little thing also is that if you notice, if you're following the PCCD protocol development tools, part of the exercise you're supposed to go through with your team and spell out in each protocol is how you're going to meet those protocols. And that's important because these protocols apply to different components of the team, law enforcement, prosecution, et cetera. And it's important that all the law enforcement, et cetera, know what these certifications are, because there's some things that they're expressly not supposed to be doing under the certifications. And I think that Darren and Mary will be going over some of those things today and hopefully explaining to you a little bit about why those things are there and that it's just isn't something arbitrary written into the law. So I want to thank both of them for being here. They are national experts. And, Darren has introduced himself, and I'm sure Mary will be next to introduce herself and tell you a little bit about what she does. So thank you.
Thanks so much, Natalie. Yes, hi, I'm Mary Siefman. I'm the Director of Policy and Justice Initiatives at Also. And one of our projects is the STAR project, which stands for the Stop Technical Assistance to Administrators Resource Project. However, although we work with all of the STOP administrators in the 56 states and territories, we also provide training and TA, technical assistance, to subgrantees. So that's available. And that's one reason we're talking to you here today. So we work with all STOP subgrantees and STOP grantees as well. So as Darren mentioned, we are the comprehensive training and technical assistance provider for the STOP Formula Grant Program. And what that means is that we provide guidance, assistance, consultation, tools, materials, and we're a one-stop shop for all of the needs that STOP administrators may have related to either their role as a federal applicant and a grantee and making sure that they're compliant with all of the federal requirements, their role as a state a grant administrator, and then also as a leader on these issues in the victimization areas and thinking about how to incorporate good strategy in order to meet needs, overcome barriers, and so forth. So we work with STOP administrators on all of those areas. That's why we're here today, and happy to be here. And I will hand it back over to Darren to start talking about the certifications.
Thank you, Mary. I'm going to go ahead and try to share my screen here. If you can see my screen, can you give me a thumbs up? The slides, awesome. Thank you. Never sure if that's going to work. I'm glad it is. So yes, this is our webinar on the VAWA STOP certifications, tailored to the work that you're doing in Pennsylvania, although these certification requirements do apply to all the states and territories that receive the STOP money. And as I'm sure many of you know, it's a formula program. So each state and territory is awarded money to be passed through to subgrantees in proportion to their overall population. And it's actually the biggest pot of money that the Office on Violence Against Women administers. I'm sure that many of you have experience with discretionary funding from OVW, from the Office on Violence Against Women, through other projects like the Improving Criminal Justice Response or ICJR project, which often goes to prosecutors' offices, law enforcement, sometimes community organizations around their response, and the Justice for Families program and others as well. That can go to sometimes on a statewide basis, sometimes to individual communities, courts, and organizations. This, as you know, this formula grant program is a bigger pool of money that can be used, that Natalie and her colleagues set through work with advisory groups and doing outreach throughout the state to see what the needs are, what some unmet needs are and challenges, and then through their grant making can really improve the response to the Violence Against Women Act crimes in Pennsylvania. But in order to be eligible for that money, as Natalie said, her agency has to certify to the feds that all of these things are happening. We're going to talk about what all these things are happening in Pennsylvania. And it's an interesting situation because in many of these areas, Congress, the US Congress, can't pass laws to require states to do certain things. It's really up to the state legislatures to do that. And so really part of what's behind the certification requirements is that the feds, the Office on Violence Against Women, and Congress actually creates these certification requirements, says that these are best practices. These are what we want to see all organizations that are funded with our money implement, primarily for victim safety, but also for offender accountability and for effective and efficient programs. And so they use the power of the federal purse to say, in order to use this money, you need to meet these requirements, certify that you're doing these particular things or not doing certain things that may be endangering to victims. And that's really kind of the overall idea for why certifications were made part of the Violence Against Women Act from, as Natalie said, the very outset. So what is a certification requirement? It's not just something that you check off, as Natalie said, when you have the opportunity to submit an application or either to the feds or to PCCD. It's really a way of ensuring that practices are meeting the needs of victims and are not endangering them and are meeting best practice standards. And that's why they matter. It's really, it's a question of tried and true practices, making sure that they are, used throughout the country. And that one of the really nice things about this is that we all learn from each other. And I know Natalie and her colleagues have been involved in conversations with folks from other states and territories around some of these issues. And it's really a great opportunity to learn emerging good practices and disseminate them around the country. And Natalie laid out the answer to the third question, who's responsible for making this certification. It really is kind of a two-pronged piece. PCCD has to certify to the Office on Violence Against Women that efforts are being made, or these practices are being put in place in order to be eligible for that formula grant money. And subgrantees, as we'll talk about more specifically as we go through this information, have to certify to PCCD that their agencies, their organizations, their units of local government are ensuring that these practices are in place, so the certification requirements are being met. So we have to remember that it's both of those levels at which it's happening. In terms of what we're going to cover for you, we're going to do, I'm going to take you through the certifications relatively quickly, although with an opportunity for you to ask questions or make observations as we go through. And then we're going to do a little Jeopardy game to kind of reinforce some of the learning. Towards the end, we're hoping we'll have some time at the very end for some questions too. But again, either hit the raise hand button or just speak up. You can unmute yourself and speak up if you would like to get our attention and would like to share something with the group. So having said all that, what we're going to talk about today are the major certification requirements, some of which are kind of an ongoing active issue, like the certification around prosecution that Natalie mentioned, because it's so new and we're still trying to figure out what that looks like. Many of them have been there for years, and for most of you are probably a non-issue, but it's always good to go back and think about, to make sure that it's really a non-issue, that you're meeting the certification requirements, and to understand why they're there. So we're going to talk about the forensic medical examination payment requirement. We're going to talk about the no fees charged, costs or fees charged to victims in criminal cases and protection order cases, and what that looks like. We're going to talk about the judicial notification, which touches upon firearms specifically. And I know from having worked with folks in Pennsylvania for many, many years, that issues around firearms in especially domestic violence cases, it's an ongoing thing. So we can spend a little bit of time talking about that, specifically what the notification is about, but the practices that are kind of behind that. Polygraph testing and that prohibition on requiring polygraph testing of victims to move forward with their criminal cases. And then the evidence-based prosecution, or the prosecution certification, which is officially that your grant eligibility is dependent on not compelling victim testimony, except under very limited circumstances. So we'll talk about what that is. And we're actually going to spend most of our time on that one because it really is the most active of the certification requirements. Finally, we'll talk about the legal assistance certification. These funds can be used, and they may be already in Pennsylvania, to fund legal services. And to the extent that's happening, there are certain requirements that need to be in place, mostly to protect victims and to make sure that the people who are providing legal services understand domestic violence and the other VAWA crimes and implement a safety and trauma-informed practices. So that's what we'll talk about. I'm going to dive in. Again, raise your hand. I can see if you raise your hand. I'm monitoring chat. You're more than welcome to chat something in. We'll all pay attention to it. And so here we go. Let's start with forensic medical examination payment. And I know generally this is not an issue in Pennsylvania from some conversations I had with Natalie and her colleagues. However, with staff turnover and other changes, sometimes these issues kind of rear their heads unexpectedly. So we want to make sure people are on the same page around this. And the basics of this particular certification requirement is that if you are a state, an Indian tribal government, or a unit of local government, a county government, a municipal government, and you're receiving OVW stop funds for any kind of activity, not just sexual assault related activity, you have to certify that for forensic medical exams, forensic rape exams, FREs, FMEs, they're called a variety of things, that they are available to victims without charge, and that it's actually the state, the tribal government, or the unit of local government is going to pay for it and arrange for it to be free for victims. And not only that, there's a second part to the certification that sometimes is forgotten. There also needs to be some kind of coordination around notification or communication with victims that you can get a free rape exam from whoever you need to go to get it, whether it's to a hospital or a local service provider or wherever that's going to happen. And so there is this element of letting victims know that this is an option and it's a free option. So why do you think the certification requirement is put in place? We're starting with kind of a softball. Why would the feds decide that they would condition money, to stop money, on you meeting this no fee, free forensic medical examinations? Does anyone want to chat in what their thought is around, or you can unmute yourself and tell us what you think? So there have been issues, and there may have been issues historically in Pennsylvania around people being charged for these examinations, and for that being a deterrence, right, from actually going ahead and participating in this, very invasive, but in terms of having a legal system response, important step of along the journey of someone who has been a victim of a sexual assault. And as Natalie mentioned, you have a system set up in Pennsylvania where your VCAP program pays for the forensic rape or forensic medical examinations. So you have something in place. It shouldn't be a challenge in Pennsylvania, but we know that sometimes in hospital settings, people are asked instead to use their health insurance if they have it. And there can be other things that victims are told when they are when they are considering or in the process of trying to get an examination done. So it's really the idea here is we don't want cost to be an impediment to this being a choice for victims to move forward and have their cases prosecuted. I see someone Heather, you have your hand up?
Yeah, hi. I work as a sexual assault nurse examiner at Penn State Health St. Joe's Emergency Department. And I know, although we have the VCAP and the exam is free, there's still a lot of issues regarding this and explaining it to the patients, because it does not cover, if we x-ray the arm or have to do a CAT scan because of possible strangulation. And there's been a lot of issues where the patients get really upset and, had they possibly known that, they may not have come. So, I ultimately would love to see any aspect of their care for reporting for a sexual assault, obviously to be automatically covered by Pennsylvania. But in the meantime, I think it's really important that we do explain very carefully that the actual sexual assault exam is free, but any other additional care based on the circumstances may not be.
Thank you very, very much, Heather, for weighing in on that. That's a really important point that's sometimes missed. And as you said, people learn the hard way, right? It's really an awful situation. And as Natalie said, so VAWA, at least at this point, is not going to cover, is not going to require that that's all covered. That could be something that comes down in the future, or it can be fixed legislatively within Pennsylvania, but it's a really important point. Thank you. So this requirement is that the exam itself is free of charge, not the other aspects of the medical examination or the medical treatment, as Heather said, or to arrange for victims to obtain these things for free. So either the government entity pays or arranges for folks to get free services. And just as another piece of all this, I know you have the VCAP program. Technically, the STOP program itself can pay for these examinations as well. This is one of those instances in which the STOP funds, the Violence Against Women Act funds themselves can be used for the payment. That's not always the case. We'll talk about that when we talk about fees in just a little bit, where that's not the case. But here, STOP funds can pay, provided they are done by a qualified, certified mental health provider, typically a sane nurse or a safe nurse, and that there's no requirement that the victim seeks reimbursement from their insurance carriers, which is a practice that we've seen previously. So the other piece around this, which is important, and I don't know if it's an issue in Pennsylvania, but that is you can't require, or and we'll talk about what that may look like, a person to submit to an exam in order, or to cooperate with law enforcement, or to participate in the criminal justice system to pay for that exam. And so there can be no condition that you get this for free if you participate in a prosecution for the sexual assault. It has to be free, period. So there's no disincentives for victims under those circumstances. So that's all I was going to say about the forensic medical examination piece, because I think, in large part, it is relatively straightforward. And Natalie talked about how counties are discouraged from using STOP funds. There are other uses for STOP funds because of the VCAP program. And so, at least in Pennsylvania, so far, that's not been the favored way to go. So I'm going to move on to the next certification, which I just mentioned, which is the no fees or no fees and costs certification. So once again, this is a certification that applies to the same entities, the state of Pennsylvania, any Indian tribal governments, and units of local government. And it is around criminal domestic violence cases and sexual assault cases and stalking cases, and human trafficking cases. Actually, it's not human trafficking is not part of this. I apologize. Stalking cases, criminal and also protection orders, both civil protection orders, and to the extent that criminal courts are issuing protection orders, those kinds of protection orders as well. Those entities have to certify that a victim does not have to bear any costs or fees associated with any of those cases, types of cases. So of course the question is, what are the costs that we're talking about here? What does it include? Well, for criminal cases, you can see this is the language of the certification itself. So in connection with any of these types of prosecutions, whether they're misdemeanor level or felony level, these fees and costs can't be charged. And they relate to filing the criminal charges, the issuance, filing, issuance, registration, modification, et cetera, of any warrant, any subpoena in the case, anything else associated with the criminal case, whether the case is happening in Pennsylvania or outside of Pennsylvania. And so no aspect of a criminal case, none of those charges that courts can charge to individuals shall be charged in order for you to remain eligible for your large stop award. On the protection order side, similarly, no victim should ever be charged a filing fee, a fee for issuing the order, for registering the order, for modifying the order, enforcing the order, asking for a dismissal or withdrawal of the order, for service of process of the order, whether that service of process takes place in Pennsylvania or law enforcement in Pennsylvania has to reach out to a law enforcement agency in Maryland, in New Jersey to get the order served, in California. Those fees should not be charged in any of those circumstances, whether the case is in the state of PA or outside of the state of Pennsylvania. So your courts make that certification that no court fees are going to be charged. Prosecutors shouldn't be charging any fees. No one should be charging fees in these cases. So I already mentioned some of the nuances here. What I mentioned was the interjurisdictional case. And so I've worked on this issue with Mary for something close to a quarter of a century. She's been working on it longer than I have. And it is from when I started this work in 2000 to today, I can tell you that people are being charged fees for interstate service of process. The agency in the other state asks for $50, $100 to serve the order because there's personnel time, et cetera, involved. They cannot do that and be eligible, remain eligible for their stop funding. And in fact, I know that I'm sure Mary has been on the phone talking to folks within those states saying, look, you can't do this. You're going to render your state ineligible for this big pot of money, ultimately sometimes calling the state administrator in those states. And so this is a real thing that's out there. And so if any of you learn that someone is trying to charge a fee, even in a weird interstate situation, in association with a criminal case, a subpoena, or a witness a petition or anything like that, or in a civil protection order case for service of process, they can't do that. You can call us. There are others you can call. We can try to work on that. Now, what about a divorce or a custody case, a domestic relations case, not a PFA case? Can fees be charged? No, you cannot charge a fee associated with a protection order. Protection order is defined in the statute. It's basically any order that's to protect one person from another person. It's very broadly written. However, if there's a separate filing fee for the divorce case or the custody matter, whatever else is happening in domestic relations courts, those fees can be charged to victims, but just not in conjunction with a protection order. So oftentimes, of course, we work with people to make sure that they can do it for free, and there are waivers and things like that. But technically, STOP covers the protection order side of things. And there are protection orders that are issued as part of divorce or custody cases. No fee should be charged for the filing, request for one of those, service of one of those, or anything else associated with it. Again, please interrupt if you have questions, raise your hand, chat in anything you have. I want to make sure that I'm answering all of your questions. Stop funds, can they be used to pay or reimburse these fees? Well, this is an instance, unlike what we talked about previously around the forensic medical examinations or the forensic rape examinations, in this instance, you cannot use stop funds to reimburse people for fees. The certification works that you're not eligible for the money unless you certify that you're not charging these fees and you can't use the money from stop to pay for them. So other sources of funding have to be used to pay for the service, for the filing, for et cetera, of these cases, so that the victim doesn't incur them. Finally, what if a PFA petition is denied? What if the court decides that the burden of proof has not been met, or for whatever reason, that the person can now be charged the fee? Is that allowed under the stop certification? Does anyone know the answer to that question? Want to venture a guess based on kind of the philosophy behind a lot of this stuff? Of course, the philosophy behind this one is money should not be an impediment to seeking safety from the courts, right? Whether it's a criminal case or a civil case. So the answer to this is a little tricky. If the denial is because the court adjudicates the person not to have been a victim, if there's a finding that there was no abuse, then technically a fee can be charged because they're no longer considered a victim in the case. However, we know that sometimes petitions are denied because the abuse took place too long ago and the court doesn't find that the threat is imminent enough or current enough. Under circumstances where the court doesn't make a finding specifically that the person is not a victim, fees should not be charged because they are still a victim under the Violence Against Women Act. They have been subjected to abuse of this form, but it may not have met whatever the specific burden of proof within Pennsylvania is. So this can be a tricky area. Best practice, you don't charge fees, period. And you don't charge fees even if a petition is denied, in part because it discourages people from coming forward again if they are, re-victimized and maybe there's more current abuse that's taking place. And there's a whole lot of reasons you wouldn't want that to have happen, of course, for victim safety purposes and offender accountability purposes. But technically speaking, unless the petition is denied because the person has been adjudicated to not be a victim, no fee can be charged. I hope that makes sense to everyone. Again, ask me any questions you have around that particular piece. I'm going to move on unless, are there any questions around what we've talked about so far? The fees and the FRE, FME piece? All right. I'm going to move on to talk about the judicial notification. So again, the federal government can't come in and say, Pennsylvania, you shall have this kind of firearms related law in cases involving domestic violence, stalking, sexual assault. Instead, the federal government, Congress, decided that it, at the very least, wanted people against whom a protection order was issued or who have been convicted of a domestic violence related offense, specifically a misdemeanor crime of domestic violence, to be notified that they may not be eligible to have a gun under federal law, regardless of what state law says, although state laws are also mentioned in all of this. So the idea is that we want people to be notified when that PFA is issued against them that they may not be able to possess, purchase guns or ammunition. And if you look at the certification language here, let's parse it just a little bit. Again, this is states and units of local government. So local courts, you have a centralized, and then we have at least one person from the Administrative Office of Pennsylvania Courts, and we're glad you're here with us. And it's centralized, and it's on all your PFA forms, this notification. And we need to make sure that people understand this. So generally, it's met in Pennsylvania, but also your policies and practices should be consistent with that. And ideally, best practices, judges are going to say something about it, or someone, or the respondent and the petitioner, the protected person, will get some sort of notice that this is the case, that the person is not supposed to have access to their guns. And even better, they have to turn in their firearms to law enforcement. And there's lots of issues around firearms relinquishment, which we could talk about if you'd like to. But generally speaking, the stop requirement is this notification. You'll note that it refers to 18 USC, 18 US Code, section 922G8 and 922G9. 922G8 is the part of the Federal Gun Control Act that was amended or was introduced as part of the Violence Against Women Act way back in 1994 when VAWA was first enacted that says that if you are subject to a qualifying protection order, you can't have a gun or ammunition. So your PFAs qualify under that. And that's why that notice requirement, and actually the next slide shows you the language from your PFA order, which mentions 922 G8, 18 USC 922 G8. There is another aspect of the notification. The notification says both 922 G9 and G9. 18 USC 922 G9 was introduced 2 years after VAWA. Some of you may know it as the Lautenberg Amendment, named after Frank Lautenberg of New Jersey, who was the person behind this amendment to the Federal Gun Control Act. The first time that the Federal Gun Control Act included a prohibition based on a misdemeanor. In this instance, a misdemeanor crime of domestic violence. So your assault charges, your battery charges, in which there's a relationship, an intimate partner type relationship between the parties. Those folks can't have guns for the rest of their lives as long as that order, as long as that conviction has not been expunged or removed from records. And so notification is required also under VAWA, under the STOP certification requirements, that you tell defendants upon conviction that that qualifying misdemeanor crime of domestic violence renders them unable to possess or purchase a firearm moving forward, period. So this is something that we work with criminal courts on, making sure that they have instructions to the convicted person, including it in orders of conviction, and otherwise letting people know all of that. And someone has a great question about what if the perpetrator is in law enforcement? And that's really an excellent question to help illustrate some of the subtleties and weird differences between some of these laws. So 18 USC 922 G8, the one that's related to PFAs or other types of protection orders, that prohibition has an exemption that basically says that for people who are government employees, law enforcement, corrections, etc., who have to carry a firearm as part of their official duties, 922 G8 does not apply against that possession while they are on duty as to that duty weapon. They can't have their personal weapons, but they can have access to their duty weapon while they're on duty. Best practices that we've been promoting for many years, and I think have been implemented, if I remember correctly, in Pennsylvania and some agencies, maybe even many agencies, is that people who are subject to these kinds of PFAs and are sworn officers who have firearms, under agency protocols and practices, they don't have access to firearms even on duty because of the danger that they pose, and they're assigned to different duties for the duration of the order. 922 G9, the other piece of this, the misdemeanor crime of domestic violence, does not include that exemption. So those officers are not able to have access to firearms, duty weapons, non-duty weapons, for the rest of their lives if they're convicted of a misdemeanor crime of domestic violence that qualifies and it's not been expunged. So I hope that answers your questions. There's a lot of other nuances and subtleties. If you have questions around firearms and firearm implementation of good practices and stuff, reach out. We can assist. Also, STAR can assist. There are other organizations out there that can provide you training and technical assistance in these areas. So thank you for that question. So let's talk about polygraph testing, the next prohibition or next certification I wanted to talk about. And in this instance, the language about who has to certify, in addition, of course, the PCCD to the Office on Violence Against Women, it applies to the state of Pennsylvania, Indian tribal governments, territorial governments, and units of local government, like the ones that we've talked about so far. And you have to certify that your laws, policies, and practices make sure that no law enforcement officer, prosecutor, or other government official asks or requires adults, youth, or child victims of alleged sexual offenses, either federal offenses or state, tribal, territorial, or local offenses, to take a polygraph test, submit to a polygraph test or other truth-telling device. I'm not sure what those are, but many of you probably do, as a condition for proceeding with the investigation. So unless you take this polygraph test, we're going to end things right here, right? We're going to stop. We're not going to investigate this crime. We want to make sure you're telling the truth. Or even shall ask, right? And so making this request and saying, we want you to do this because otherwise we're not going to be able to pursue the investigation. Would you be willing to take a polygraph test? You can't do that and remain eligible for your large stop funding that comes to you. The other piece of the certification is that the refusal of a victim to submit to a polygraph test can't prevent either the investigation, the charging, or the full prosecution of the alleged sex offense. So if someone refuses, the flip side, you can't then stop the investigation on that basis. So the federal government, Congress, was very serious about not requiring polygraph testing of victims. Do folks have some ideas for why this may be the case? Again, what's the reason, the rationale behind this particular certification? If anyone wants to raise their hand or anyone wants to type it in, I'd appreciate it. Make sure people are out there listening. It's always hard in these virtual settings. So polygraph testing is, generally understood fear. So the fear, and I'm assuming, and you're welcome, Denise, to unmute yourself and elaborate if you would like, or I can try to. I think what you're saying is that there could be a impediment to moving forward, and we want to encourage people who want to move forward with criminal prosecutions to do so. That this polygraph, who knows how it's going to turn out, right? And it's a pretty invasive process to be asking these questions and your responses to be engaged. So it's further victimizing or traumatizing a victim at a point where we certainly don't want to do that. They're not the person who did something wrong. They're making they're a victim of a crime who are coming to you for help. And in some instances, they're not admissible too. There's other issues around the admissibility of polygraphs, of course. And so to some extent, asking someone to submit to polygraph testing is saying, I don't believe you, prove it to me, right? At the very beginning of an investigation of a crime, of violence. So absolutely. And it can inhibit people. And so a lot of this is about trying to stop, to reduce the barriers to these very invasive proceedings that we want people to be able to take advantage of if they need it, but to not create impediments that are going to further traumatize them. So thank you. I appreciate those of you who responded to my question. So again, what if I request but don't say I ain't moving forward unless you submit to this polygraph test? There's some guidance from OVW. OVW, of course, and let me just make sure that we're all on the same page. OVW is the Office of Violence Against Women. It is part of the U.S. Department of Justice that administers the Violence Against Women Act and all its funds, including the STOP funds. And so OVW has a role in making sure that all of the states and territories are complying with these certification requirements. And in fact, if they find that you're not, they'll reach out. It's a process. And sometimes we at Also Star are involved in that process in helping navigate it for folks. But they'll reach out and say, your practices are problematic and you could be ineligible for this funding. Let's talk about how we can make this all work. And we've done that several times with states. So OVW offers guidance around these certifications. And actually, if I could ask maybe one of my Also Star colleagues, because it'd be easier for you to maybe type in the link to the frequently asked questions that the Office on Violence Against Women at Thank You has put together around many of these questions we're talking about today. But they've explained that these requests can be inherently coercive and re-traumatizing. And really, it should be extreme circumstances, and you need to be able to justify. And certainly not as a routine matter that your victims are going to submit to polygraph testing, and that you need to exhaust all reasonable alternative investigative methods. You're going to hear this language again when we talk about the, thank you so much, Shosh. When you hear the when you hear about the prosecution certification in just a minute. But this is, the idea is they really want to prevent this from happening. So I'm going to move right into evidence-based prosecution unless there are any questions or comments around anything that I've talked about so far. Again, you can use chat, unmute yourself, raise your hand, whatever you're comfortable with. All right, so let's move in to the evidence-based prosecution certification. And this is the one that we were going to spend a little bit more time on because, as Natalie pointed out, it is new. It was introduced in the reauthorization of the Violence Against Women Act in 2022. It applies to funding from fiscal year 2023, of which there is some in Pennsylvania, and moving forward. The new requirement is that, again, PCCD is going to have, Natalie and her team has already made certifications to the Office on Violence Against Women that this requirement will be met in Pennsylvania. But in addition to that, PCCD has an obligation and role in hearing from prosecutors' offices around their compliance with the certification requirement. And so what that means is that all prosecution offices in the state of Pennsylvania receiving stop funding for prosecution of Violence Against Women Act cases has to certify that they will, during a 3-year period, so we have 3 years from the start around now with the fiscal year 2023 money starting to go out and be used, a 3-year period starting at the issuance, the award date for the grant, that you will engage, your office will engage in planning, developing and implementing 3 things. And you don't have to do it alone. I know there's statewide efforts in Pennsylvania amongst for prosecutors. There are national providers on this, in our technical assistance providers. We'll talk about all that. It's not something your office has to do alone if you work for a prosecutor's office and you're listening to this. But what you need to do with help is develop training, or at least make sure that prosecutors get training, that you develop an office-wide policy and a protocol in this area. So let's talk about what that looks like. The training piece around evidence-based prosecution. And let me just very quickly, okay, let me keep going, sorry. The first piece is the training. So you need training around victim-centered approaches to domestic violence. The idea of around the evidence-based prosecution, the victim-centered approaches to prosecution is that you're not going to use what we sometimes call next level approaches, which means essentially subpoenaing, using material witness petitions to compel victims of the VAWA crimes to serve as witnesses, to testify at a domestic violence, a sexual assault, a stalking trial. So first of all, you need training. The training needs to be developed by experts in the field, and it has to be about victim-centered approaches. And we're going to talk about what those look like. For those of you who are not well versed in this area, we'll talk a little bit about what a victim-centered approach is and the things you can do to not compel testimony. You also have to develop a policy that supports such a victim-centered approach that is based upon and informed by the training that we just talked about. Finally, you need a written protocol that's going to outline where the rubber is going to meet the road on this. It's got to really outline in some detail what the other approaches and procedures you're going to use to compelling testimony through material witness petitions or bench warrants. So a bench warrant, you go to the judge and you show that the victim's not coming, the victim's necessary for this prosecution. The court issues a bench warrant. It's really a warrant to pick up this person and compel their testimony. Or prior to a trial, if you think this is going to be an issue as a prosecutor, you can seek an MWP or material witness petition to compel that testimony. So you need alternatives to that are consistent with best practices, that are exhausted before you start to use those next level means of getting victim witness testimony. And I'm going to talk in just a few minutes about what that looks like. And this is applicable in the investigation, the prosecution, and the trial of these crimes, the VAWA crimes, DV, sexual assault, dating violence, and stalking. And the idea is written right into the certification requirement. It's to prevent further victimization and trauma to the victim in these cases. So a couple things to say about that certification, and I'm happy to take questions. And as Natalie pointed out, your STOP protocol revisions are going to involve, addressing these parts of the evidence-based prosecution requirement. First of all, the requirement is not that you never compel testimony through a material witness petition or bench warrant. Instead, as I said, it's about exhausting alternatives. Compelling testimony should be a last resort. It should certainly not be routine or even common. One of the prosecutors we work with, who's been doing this work on a national level now for a very long time, did a presentation for us recently and talked about it as being like a once in career, maybe twice in career kind of thing. There should be alternatives to compelling testimony because of the re-traumatization and because of all the reasons why we don't want to do that, which I'll talk about in just a second. So let's talk about what this needs to look like. First of all, as mentioned previously, your STOP administrator, Natalie, and her colleagues have to certify that they've been imposing this requirement on prosecution offices that receive STOP funding, and they've already made that certification. In turn, the requirement is that the head of the prosecution office has to certify to PCCD that they're in compliance, and that it's the office as a whole is in compliance. So a little nuance around here. This doesn't mean that all of your prosecutors, including your prosecutors who are not prosecuting Violence Against Women Act crimes, domestic violence, sexual assault, stalking, dating violence, are in compliance. This is really about your prosecutors who are prosecuting those kinds of cases, but it's all of those prosecutors. So if you're in a prosecution office that uses STOP funding to pay for 2 of your VAWA type, your DV sexual assault prosecutors, but you have 2 other ones, you have to certify that all of your domestic violence sexual assault prosecutors, all 4 of them, have been trained and are following these policies and protocols. I hope that makes sense to folks. It's not as to your non-domestic violence sexual assault prosecutors. They don't have to submit to the training or participate in the training. And technically the protocol doesn't have to apply to them because they're not prosecuting these kinds of cases. But anyone in your office, if you're receiving any STOP funding for prosecution, has to comply. So that's how this certification works. What about the when? The when is, as I mentioned, it's a 3-year process. So for those of you who are working on this, worrying about this, as many of us are, what's it going to look like? How do we go about this? You have 3 years from when you first were awarded fiscal year 2023 money. For some of you, it hasn't started yet. For some of you, it may have started already, but there's a 3-year process. And I'm not going to go into the details of this. Is a little more for Natalie and her colleagues, but generally speaking, for those of you who have those awards, you're going to need to certify that you will come into compliance within 3 years. And you need a plan and an explanation for how you're going to do that. That can be that you're going to attend trainings that are offered by national experts like Equitas, which I'll talk about in just a minute, a national technical assistance provider with which we work that provides these kind of trainings. That you're going to work with a statewide prosecutors association to develop a policy and a protocol that's tailored to your office. What you're going to do over the next 3-year period. Second time around, you explain how far you've gone in that process, what's left. And then by the end of the 3 years, you should be in a position of certifying that it's been done. You have the policy, you have the protocol, and folks are trained and will be trained as new people come into the office over the course of time. So there's a 3-year thing. You don't have to do it immediately. You have to have a plan. We can help you with a plan. I know that Natalie and her colleagues at PCCD can help you with a plan. And I know there's statewide efforts as well to get help for how you can do this. I am curious, what do folks think? Why would there be this prosecution certification where you have to show that you're going to do everything you can to not compel victim testimony? And you can just type in a word or two that you think explains what's happening here. And I'll give you one word: re-traumatization, right? And also understanding an understanding of why victims may decline to pursue prosecutions. This is all grounded on a victim-centered understanding for why some folks don't want to move forward with a criminal case, sometimes even where there's been significant abuse and there's a chance of future abuse. We know that victims, survivors have to make calculations in their mind. Obviously, with the help of an advocate and a prosecutor to talk through some of this stuff can be super helpful, and we'll talk about that. But it's a calculus that everyone has to make. And the idea that's now kind of codified in federal law around the certification requirement is that we want to make sure we don't re-traumatize or re-victimize people. So there are barriers, of course, behind this, barriers that victims face in terms of participating in these criminal cases. Is anyone willing to chat or talk about, in your experience, what some of those barriers might be? Why would people not want to, why do they sometimes engage in this counterintuitive behavior to some of us? Like, why would you not want to pursue a prosecution against someone? They may continue to live with them, right? It doesn't mean that there's separation. They may think it's safer not to have this prosecution take place, actually.
Well, once the violence ends, can I talk? I'm a prosecutor, Lackawanna County. Like, once the violence ends for them, they're back to being safe. And then all they're concerned now is, okay, you know, this is the dad of my kids. You know, he's providing a roof over my head. I don't want to split the family up. The kids are giving me all this grief about, you know, why is daddy not living in a house? All of those factors.
Absolutely. Thank you so much. And obviously that's from lived experience. So I appreciate you weighing in on this. There's so many considerations, right? And so people who've been doing this for a long time understand these. Alienation from the perpetrator's family, and other people have talked about the financial dependence or childcare, as you said. So absolutely. And victim blaming, the whole family's blaming the victim, the community, the faith community, you know, there are a lot of pressures, obviously. And that's why this is written the way it is. The statute doesn't say it can never happen. This compelled testimony can never happen, but it really should be a last resort. And so here's a list of some of the reasons, many of which you already talked about. Don't have to go into a lot of detail. I hope that folks understand this. If you don't, if this is new to you, and I urge you to attend, you know, a 40-hour training around domestic violence advocacy, or learn from advocates, folks who work with survivors and victims, about what they experience when a case goes on. And, you know, the case may be prosecuted. That actually may be the most dangerous time for the victim and their children, because we see an elevated risk of harm upon separation in this way. And so many different reasons for why. And so one of the things that we want people not to do is talk about victims being non-cooperative, because it's a very pejorative term that we would ideally like to see avoided. There are so many reasons why people don't do it. It's not a matter of not wanting to cooperate. It's a matter of, again, this calculus. What's going to keep me safest? What's going to keep the children safest? How can I continue to rely on my sources of support? So many different things that could be going on. And so using a pejorative term like non-cooperative can be counterproductive. And so what are some best practices to, first of all, support a victim's willingness to participate? Obviously, a victim is willing to participate. We don't have to worry about compelling their testimony. They're part of the prosecution. This is ideal, right? So some ideas: collaborating with advocates, prosecution and advocacy. And some of you have victim witness folks, and you have system-based advocates, but working with people who understand the lived experience of victims, especially community-based advocates, can go such a long way to building trust and getting folks to want to participate. Engaging in trauma-informed practices and strong relationship building. I could spend, you know, the next 3 hours talking about what trauma-informed practices look like, trauma-responsive practices look like for prosecutors. Many of you probably already know these. But of course, to the extent that you have a welcoming office, that you have, that you are using words and approaches that meet the survivor where they are, the extent to which you don't compel them to do things to the extent possible, can help create a trauma-informed and understanding that people aren't going to tell linear stories. right? And helping to inform courts and others, of course, that trauma, the impact of trauma on how memory is encoded in the brain is really significant. And the reason people sometimes can't tell a linear story or what you would consider to be a logical or coherent story is not because they're making it up, not because they want to hide it from you, but because the way it's been encoded in their brain because of the trauma. It renders them unable to do so. Another idea here is to pre-trial, get an order from the court that has conditions that will keep the victim safe from the obviously contact with or abuse from the perpetrator, but also just to give them time and space and be away from the influence of that person. And where there is witness intimidation, investigate it and address it. And we'll talk about one way in which in which intimidation, direct coercion, intimidation by the accused person can be a part of this. So the other part, the other set of best practices, ideally you have participation by the victim. If you don't reach that ideal, we can fall back on evidence-based prosecution. And I'm sure that we have prosecutors who are with us who are experts in this, but just so everyone's on the same page around what that can look like, it starts with initial contact with law enforcement and hopefully access to advocacy, and that officers and that victim advocates who work with victims and survivors are trained and supported in how to investigate, how to collect evidence, what kinds of pieces of evidence are credible evidence of the abuse that don't require the victim to be involved. And in some instances, it can be statements, what us lawyers call excited utterances that happen at the scene that are recorded, that someone says under duress or under, in an excited state that can overcome hearsay exceptions, things like that. This requires training, it requires expertise, it requires prosecution expertise and law enforcement expertise for this to happen. But where it happens, it can be magical. It can allow for successful conviction of really dangerous people without the victim being part of that prosecution, without them having to testify. The idea of forfeiture by wrongdoing, this is illegal. This is a sort of a legal doctrine in which if the offender has caused the unavailability through their threats, their intimidation, and other things, then they've forfeited. Basically, prosecutors can move forward with the case without the victim being present. And some of the evidence can come in without the victim being present in the trial, because basically the offender caused this problem through their actions. So a very brief overview of some best practices. I know I'm just touching on this, but there's a lot of help available, including from Equitas. Equitas is a preeminent organization that has done this work. And in fact, we have a document for you, and I'm going to make sure that Natalie, I think you already have the slides. Feel free to circulate the slides to all the participants so that they can get these resources, the links to these resources. We also have some recorded stuff from Equitas, which we can share. Lots of great information, great information out there for how to do evidence-based prosecution and how to meet the certification requirement. So, sorry, didn't mean to go to that slide. We'll have some questions in our Jeopardy, which we're hopefully going to start in a couple of minutes, which we will start in a couple of minutes to reinforce some of this. But are there any questions? This is a biggie. It's new. It's affecting prosecutor offices around the country, throughout Pennsylvania. And we want to make sure that to the extent you have any, and Shosh, thank you for putting the link to the website. If there are any questions or comments that you want to share. All right, well,
I have a question, actually.
Oh, good.
Our judges, I think you said we had a representative from AOPC here. Are judges getting training on this? Because we hear sometimes from our prosecutors that if the victim is not there, not willing to testify, that the judge is really not interested in prosecuting. So are judges getting this information too?
Information about evidence-based prosecution is scheduled to be in our 2024 curriculum for the sexual violence training that we plan on doing. But I'm also going to look into if you have any suggestions for upcoming trainings that we could provide scholarships for for our judges or other members of the judiciary, because that's something that we're trying to promote, is using our AOPC stop funds to have judges attend additional conferences and access pre-recorded webinars that there may be a paywall that is keeping them from seeing it. So anything that we can put out there that we can pay for, we'll gladly accept it.
Thank you, Jamie. And definitely have some ideas around what around some of those training programs. And also an important part of this, just a little editorializing, is that those individual judges go and get that training, but that there also be a mechanism for that to be shared with their colleagues. And I'm involved in a lot of national level judicial training, and that's one of the things that we emphasize. We don't want people leaving and then they have the knowledge and their colleagues don't. So if you all can think about ways to share that information, get that information shared with their judicial colleagues, that can be really effective as well. Gene, I see you have your hand up.
Yeah, if I could just add one thing, like some of the issues that we have and that are challenging for us is not necessarily with the Court of Common Pleas as much as it is with the magisterial district judges, because there's so many of them and each one has their own, we'll just say their own philosophies and theories. And when it comes to domestic violence cases, there's not 12 district justices that are on the same page. So the minute one of the, I mean, I know a few different judges who believe that, you know, once the victim does not want, I'm not going to put her through this, you know, case dismissed. And, you know, we have those challenges. And even if we try to bring in other evidence, that may not be enough. You know, we get the constant compromise. You know, fortunately for us, and I'm not sure if there's any other prosecutors that are out there, when we have those really challenging, difficult cases, you know, I have an ability to talk to our victims and advocate for, we have a really good domestic violence court now that's been in existence 3 or 4 years. And we have had a lot of success with changing behavior. There are certainly some exceptions to the rule, but for the most part, you know, it's a 6-month program and could be up to a year program depending upon the circumstances. But those are cases where not necessarily the victims want to cooperate, but we can offer a support system for not only the victim, but then we get services for our defendant, mental health evaluation and services, drug and alcohol evaluation services, a 26-week batterers program that they have to comply with. And there are certain sanctions, like any other treatment court situation. They have to plead the highest charge getting into our program, but we've had a lot of success. And I'm not sure if any of the other prosecutors have that in their area.
Thank you for sharing that, Gene. Appreciate it. And also, hi, Danny. Thank you for sharing the fact that PCADV has a bench book for the magistrate district court judges, which I assume is what MDJ stands for. Great. All right, well, let's talk about the last requirement so we can get into this Jeopardy game here. So let me try to change my slide. There we go. Legal assistance. The Violence Against Women Act STOP program allows for legal services providers to be funded using STOP funds. And there are some protections in place to make sure that the work that's being done is in accordance with best practices, that it's victim-centered, that it's trauma-informed, et cetera, et cetera. So the certification here is that the subgrantee needs to certify to PCCD, and of course PCCD has to certify to OVW as well that this is happening, that the lawyers providing legal assistance are licensed or work directly under the supervision of a licensed attorney. You see these other requirements in terms of the different courts in which this attorney can be practicing. And most importantly, that they have, first of all, demonstrated expertise in providing this kind of assistance specifically to domestic violence, sexual assault, dating violence, and stalking survivors. Or if they don't have demonstrated expertise, that there is a partnership between the legal service provider, local legal aid, whatever it is, and typically a local domestic violence, sexual assault program that has demonstrated expertise. And there has to be training for those lawyers. And you can see it includes the various legal issues around DV, sexual assault, dating violence, et cetera, but also on evidence-based risk factors Those factors that were developed in large part by Dr. Jackie Campbell at Johns Hopkins, and homicide, risk factors for homicide. So those are requirements. You can't just be a lawyer hanging up a shingle. You have to meet these requirements and certify that you're meeting those requirements for the legal assistance part of this. All right. Again, definitely feel free to ask questions as we go through, but we're gonna, as promised, oops, why isn't it stopping? There we go. I am going to share my screen again. It's going to take me a second. I'm sorry, I have a little bit of a technical issue and have to rearrange things a little bit, but I'm going to pull up a Jeopardy game. And what we're going to ask you all to do is, let me get this going, escape. Okay. What we're going to ask you to do, we have a lot of people on. And so what I'm going to try to do is, Mary and I are going to do this together, and we are going to ask you to think for a minute about our questions, and then whoever wants to answer it, hit the raise hand button, and we'll call on you in the order that you come, and you can try to answer our Jeopardy questions for bragging rights, not really for anything else, but hopefully that's enough. Okay, here we go. Okay. Now I'm gonna, oh, sorry, it's sharing it in a weird way. Okay. I'm not gonna be able to see any of you, so Mary, I'll ask you to just make sure that you monitor the chat and all that.
Yep.
Please, thank you, sorry about that. Okay. Can you all see Jeopardy? Parody.
Yes.
All right. Unfortunately, we have good sound, but the sound doesn't work very well with Teams. So here are today's categories. We have questions around fees and costs, evidence-based prosecution, of course, and best prosecution practices. We really want to make sure people walk away with an understanding of those. And of course, you have to have potpourri. So here's our board, and there are a couple of people who I can see, and so I'm going to ask them if you would be willing to just at least select the category. You don't have to answer the question, but select a category. So Heather, I can see you. Would you choose a category and dollar amount? You're muted, by the way. You have to mute yourself. Sorry. Thank you.
Fees and costs for 400.
All right, going for the 400. So I'll start us out. Due to the extra costs involved in service of a Pennsylvania PFA outside of Pennsylvania, a sheriff's office charges their actual costs for the services, minus what it costs to serve their in-state orders. So it costs an extra $50 because of this interstate nature of this, and they're charging me $50. True or false? This meets the no fee certification requirement because they're not only charging you the extra costs. So take a second to think about this. If anyone wants to just raise their hand.
We've got some answers in the chat, but does anyone want to raise their hand and say why, what their answer is and why?
Yeah. Heather, you can, since you've already unmuted, maybe you wouldn't mind unmuting and telling us why you think it's false.
False, because you clearly explained they're not supposed to get any fees associated with interstate protections being served.
Yeah, exactly. All right. What are other Heather who I can see be willing to choose? Heather Britton, be willing to choose the next category? Thank you.
Sure. Let's do evidence-based prosecution for 300.
300.
Okay. Okay, so true or false, as long as the stop administrator certifies to OVW that all prosecutors' offices receiving stop funding will comply with the requirements, the state or territory will be eligible for stop funds. Anybody want to venture a guess? True or false? You can put it in the chat or raise your hand. You have a 50-50 chance. of being correct.
We've got a false.
Okay,
Why would this be false?
and Jean,
Oh,
Jean has
Jean.
their hand raised.
I would say true, so long as we're certifying to our state that we're compliant, I think we would be eligible.
Right, right. As long as, well, it's sort of and almost, yeah. So the prosecutor's offices have to, if we're talking about best prosecution practices, prosecutors' offices have to certify to the state, and the state certifies to OVW. So it's sort of a two-step process, at least for that certification. Yep. Yeah.
Yeah, your answer was right, but it's actually makes this false because it's missing a piece. So yes. Thank you. Actually, Jean, why don't you go ahead and choose the next category?
Okay, what's best, how about best prosecuting practices for 400?
All right. This is one of the components of effective evidence-based prosecution. So think about what we talked about in terms of we had best practices around having victims be willing to participate, and then we had a bunch around evidence-based prosecution. But I'm not going to ask Jean to answer this because I
Right,
know he
thank
knows it. We're going to give someone else a chance to answer it. Thank you, Jean.
We've got one answer in the chat. Heather said
Training.
training. Yep.
Training on what kinds of things would we want to train folks on?
On trauma-informed responses to victims and questioning and non-coercive practices for testimony.
Awesome. Absolutely. And on also training for officers around investigation of cases and evidence development, right? What are the various forms? Are they searching social media? Which I'm sure the prosecutors on board can tell you that sometimes that can be a treasure trove. Or the jailhouse calls, right? So there you go. Thank you, Heather. All right, let's have someone else who hasn't chosen yet. Would you be willing to choose this for us? I can't see everyone, so I don't know, Mary, if you can.
I can see some people, so I don't know. I guess we'd like a volunteer. Anyone want to choose the next category? And
I'll choose the next category. I
I'm
just
sorry,
I can't see them anymore.
Yeah, my fault. There
That's
we go.
okay. I'll do potpourri for 400.
Oh, beautiful.
Potpourri
Okay.
for 400. Okay. A local sheriff does not want to charge fees for service of protection orders in other states that have been charging fees for interstate service. Can they use a portion of their stop grant funds to do so? So to charge that fee? What do you think about that? Anyone?
I will
Think
just
about
go out
that.
on a limb and say they can. Yes.
You think they can?
I don't know. I'm just guessing.
Seems reasonable to me.
Yeah. Anybody else? Okay, so we've got a split here. Some say can, some say can't. So just to be clear, they cannot. Grantees can't use any funds, any stop funds to cover costs of service of process, whether it's charged directly to the victim or to the stop grant. So that's unallowable under stop.
Have to find other money for that. Absolutely.
That was
All
a tricky
right.
one.
It was a tricky one. Would anyone else like to choose the next category? We can go ahead and choose. I'm going to stick with the 400s. So training and technical assistance on victim-centered prosecution, best practices, and all things prosecution is available from this national organization. You want to chat that in or answer? Jamie?
Equitas.
Yes, we want to make sure that you know the name Equitas. Thank you. And you saw, if you scroll up in through the chat, Show shared their website. If you have trouble reaching them, reach out to us. We'll get you connected with their excellent prosecutors. They're staffed by former prosecutors, many of whom have years and years of experience prosecuting these crimes.
Okay, next category, anyone want to choose category and dollar amount? We've got several left.
Yeah, I will. Best prosecution practices for 200.
Okay.
Okay. These are 2 reasons why a victim may choose not to participate in a criminal case. So there could be many reasons. What are 2?
Re-traumatization, and blame and embarrassment.
Yes.
Exactly. Yes, you remembered very well those items that Darren went over. There are many reasons, right? That's really those are 2 of the major ones.
Yeah.
Okay.
So that not just a checkbox, it's really understanding, what's happening and trying to engage in practices that can reduce that for folks. Thank you for that. All right. I think, Randy, why don't you go since you answered that? You want to choose the next category?
Sure. How about fees and costs for 300?
Okay. True or false question. If a victim fails to appear multiple times for a criminal case, so the prosecutor decides they need to obtain a material witness warrant from the court, the victim may be charged the fee for such a warrant because it resulted from their failure to appear.
I'm going to say false.
Other people agree. I see that at least one other person voted false. I mean, this is not a standard fee, right? This is because but for their failure to appear, this material witness warrant wouldn't be necessary. You're going to stick with false? Yeah, absolutely. The answer is false. And we actually confirmed this with the Office of Violence Against Women very recently that, again, the language is no fees related to a criminal prosecution for a victim. The fact that the victim didn't appear doesn't suddenly make them not a victim anymore. And so that requirement still is in place. So they shouldn't be charged that fee.
Can I ask a related question?
Yes.
It just made me think of, is there language in VAWA or elsewhere related to contempt of court? So say a victim does actually show up and testify and ultimately does the job they're being asked to, confirms that the crime happened, but they're a little, not to use the word we don't like, but say uncooperative on the stand, but they're a little combative on the stand and they're charged with contempt and there's a fee resulting from that. Do we have an express prohibition against contempt in those situations?
Right. I don't know what you think, Mary. I don't think we don't have an express. It's not explicit in the certification language. I think given what we know about how they've responded to other questions, OVW, who gets to decide these things, would probably say no, there cannot be a fee associated with a criminal prosecution, and this is associated, but we will ask and find out for you. Yeah, thank you for that question, Heather. Hope that's not a practice that you're seeing very often.
Just once, but it kind of blew my mind, so that's why I'm asking. So.
Yeah, of course. Yeah.
I'm not sure if I'm not sure if everyone realizes that when someone has been brought in on a material witness warrant, really the issue is they have to post bond to secure their appearance.
Right,
and
that's right.
There's a bail that's set by a court of common pleas judge. So I don't know how that figures into, are they being charged some money? But I know that happens in cases, not necessarily in our cases, but there's definitely some certain homicide cases I've seen that happen where victims have had to post bond because there is a certain flight risk for them.
Right.
So just everyone should know
That's a great
that.
question, Gene. We don't know the answer to that, do we, Mary?
No, this is new. Yeah,
Yeah.
we don't have guidance on that from OVW, but that's really helpful to hear. Yeah.
We'll get it. We'll get it for you and
Yeah.
respond. Yeah, we'll send information to Natalie for circulation. Thank you for asking those questions. All right, we have a few minutes left. Let's keep going. Anyone new to ask? Go ahead, Mary, sorry.
No. That anyone like to choose the category?
I'll go again. Evidence-based prosecution for 200.
Okay. A protocol must do this before a material witness petition or bench warrant may be used to obtain victim witness testimony. So what is the protocol that has to be created in order to comply with the certification? What does it have to specify should be done before you can use those measures? Anyone recall what Darren talked about earlier? So we have our answer, try all reasonable measures, right? Exactly. And right, Julie said exhaust all other options. That's right, exhausting all alternative practices and procedures before using those more coercive methods. Yep, exactly.
Excellent. And to comply with that certification requirement, in 3 years, offices are going to have some sort of written protocol that says exactly that our prosecutors are going to exhaust all these other potential options, including everything around, victims being willing to prosecute, evidence-based practices. If none of that works, and it's a case in which it's deemed that the public safety kind of outweighs these other considerations, then as the last alternative, we can compel testimony. That's essentially what this is all about. Thank you for that. All right, next, I'm going to just speed things on a little. I'm going to go to potpourri number 300 here. True or false? Stop funds can be used for legal services only if a legal services provider has a specialized domestic violence or sexual assault unit or a designated domestic violence sexual assault attorney. Otherwise, you can't do that. Randy, you're shaking your head no, and you raised false. Denise said false. Do you say false too? Yeah, so absolutely. Sometimes people understand it to be a requirement that there be someone who's designated or that you have a unit, but that's not required under STOP. Sorry, it's the Red Cross calling me to do a blood donation. But instead, all you need, well, it's not all you need, but what you need is someone who has demonstrated expertise in this area. And there's a training requirement. They don't have to be a designated attorney or part of a designated unit or specialized unit. They just have to meet those other requirements. So absolutely, you're right on that. Right, Mary?
Okay, moving right along. I'm going to go with fees and costs for 100. Courts in my state charge petitioners a fee if their petition is denied because the abuse took place a while ago and there's no continuing threat. Can I sign the certification if this is the case? What do you think about that? What if the petition's denied? Denise, I think that Denise and Randy were referring to this question in the chat. Yeah, so you said false, right? No fees. Denise says no fees, period. That's correct. Right. So if the abuse took place a while ago, that person still was victimized. And unless what Darren said earlier is that unless the judge made a finding that there was no abuse, then, that there cannot be a fee charged in that case.
So I see we have 5 minutes left with you all, and we definitely want to respect everyone's time. So we can send out the rest of these slides too, so you can look at them as well and learn from them. A lot of it's a recap of what we talked about earlier. Let me stop sharing. But I just want to make sure there are no outstanding questions or anything else that folks want to raise. We don't have a ton of time, but at the very least, if you have a question, we can get back to you, talk to you about it. After this, we're available. Mary talked about the technical assistance that's available to sub-grantees as well as the STOP administrators. So we're very happy to help you in any way that we can or connect you with resources, people who can do that. But are there any questions before we all say goodbye?
If you think of a question, I know sometimes things don't come to me until well after I've had a chance to let all the information spin around in my head for a while. You can certainly email them to our resource account, and then we can funnel them to Darren and Mary. We'll be glad to do that.
Yeah, so we hope, thank you, Natalie, absolutely. And we hope that you found this helpful. Had you think a little bit about why you're maybe checking some boxes on the certification, what's behind them and what needs to be done in order for you to check them correctly, accurately. So thank you for spending your time with us today. I know everyone is super busy in their work, and thank you also for, I know so many of you are doing really incredible work in Pennsylvania. For victims, holding folks accountable, and we really, really appreciate your participation. And the invitation, Natalie, thank you for inviting us.
Thank you. Took the load off of us.
So we'll see you
Okay,
all
well,
soon.
this concludes the third check-in. Thank you all for being here, and there will be more to come. Thank you.
Bye, everyone. Thank you.
Thank you. Bye-bye.